October 15th. Presiding Officer John Swafford, present. Mr. Joel Limley is not present. Mr. Douglas Olmixon, here. Norman Seaton,
Present.
Shelley Wiedner, and Rick Stroud.
Here.
And that does give us a quorum. Sign the paperwork. Give everybody a chance to look at the minutes. Then we'll, after you've read the minutes, entertain a motion to approve the minutes.
I'll make that motion.
Mr. Norman Seaton makes the motion to approve the minutes. Do I have a second? Only two.
Second.
Rick Stroud, seconds. All in favor?
Aye.
Opposed? And that carries. The second signature of the day. All right, on to item D, training for board members.
That's correct. So my name is Derek Burkhalter. I'm the new Assistant General Counsel for TDLR, and I have the privilege today of feeding you your vegetables and taking you back to school and making sure you get your annual refresher training for open government. So, let me get some water to make sure. Okay, so hopefully this is a review for most of you, but if you have any questions, feel free to stop me and we can discuss anything you need clarification on. So we're dealing with three different chapters of the Government Code: the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. So first, we'll get started with the Open Meetings Act. Now, the purpose of the Texas Open Meetings Act is to ensure open and transparent government. The act requires meetings of governmental bodies to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting. The provisions of the act are mandatory and are to be liberally construed in favor of open government. So if there's ever a question or a close call, we want to err on the side of being more transparent. Now, important key concepts, and these are going to kind of build on each other. The first is a quorum. A quorum is a majority of the members of the advisory board or committee as fixed by rule or statute. A quorum of a governmental body must be present in order to make an official action. And if a quorum is not present, the board, they may meet and discuss, but they may not take any official action. So if we didn't have a quorum, we could go ahead and just have a meeting of just discussion, but we're not allowed to take any action on anything. The next term is deliberation. A deliberation or a discussion is a verbal exchange during a meeting between a quorum of governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. A meeting occurs anytime a quorum of a governmental body engages in a deliberation regarding public business or public policy over which the governmental body has supervision or control, or anytime the body takes formal action. Notice, the act does require advance written notice of the date, time, place, and subject of each meeting held. And
Question.
Yes.
Is there a certain time period you have to wait? Could I do it the day before, or do I have to do it 6 months before?
For the notice?
Yeah.
The notice, there is a day, is it 5 days?
It's delinquent, it's 7 days.
7 days.
7 days.
So it has to be posted 7 days prior to the meeting. And so any topic that needs to be discussed needs to be determined prior to that point, so we can have that 7-day notice. Because we don't want to surprise the public with anything. We want everyone to know what the meeting will be about. Our notice must be filed with the Texas Secretary of State, which we do by filing it through the Texas Register. And yeah, here it is, at least 7 days prior to the meeting, and it must be posted online both by TDLR and the Secretary of State. And a board may not engage in discussions about a subject not included on the agenda. Again, we don't want to surprise anyone. We want everyone to know what the meeting is going to be about so they can choose to watch it or attend and not be surprised. So what about social functions, conventions, and workshops? So this is kind of a hypothetical, keeping in mind that a meeting occurs when and wherever a quorum of a governmental body engages in discussion about public business. Can members ever meet in an informal setting without violating the Open Meetings Act? And the answer is yes, they can. Members are free to engage in conversation that is incidental to the event, and that's a key phrase. The gathering will be subject to the Open Meetings Act if a quorum of members is present and the members either engage in a discussion about board business or take formal actions. So, you know, if you're at some national convention for auctioneers and you just happen to be having an incidental discussion about things related to that convention, that's okay, as long as we're not specifically discussing public business involved with your board and you're not taking any official action. You're not voting, you're not, you know, taking positions or anything like that. You can participate in the convention, but only in an incidental way.
So I have a hypothetical for you.
Sure.
Rick and I are at an auctioneer convention and we're on an open panel for discussion. We don't have control over what comes up in that open panel. As long as we do not communicate with other board members, are we okay if there are only two of us on the panel?
Well, and then there could be the risk that one of the board members is out in the audience as well.
Yes.
So this would be a good example of this convention sort of exception. As long as, you know, and it can be kind of splitting hairs, but as long as your discussion is, I guess in more of general terms, dealing with the association or convention's purposes, and you're not specifically saying, you know, we on the auctioneers board of TDOR have decided to do this or that. I mean, I would say it's all about how you frame your discussion. You would want to do it in a more general way that can be generally applicable to the whole industry and not specific information dealing with your deliberation as board members.
Okay.
So there can be a lot of gray area here, and this is one of those areas where we want to err way on the side of being open and being very cautious.
Okay, thank you.
Any other questions about this sort of social function exception we have here? And this is actually in the statute itself, so the legislature has taken into account those sorts of events, and they want you to be able to participate, but still be cautious about violating the Open Meetings Act. Okay, a few key points to remember. Always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present. You never know when your fellow board members may be at an event, so you kind of have an extra social obligation to be aware of who is in the group that you're with. Do not engage in substantive conversations relating to board or committee business or policy when a quorum is present and you are outside of an officially noticed and scheduled meeting. And beware the walking quorum. So the walking quorum occurs when fewer than a quorum of members engage in discussion about official business and then communicate those discussions to other members. So while fewer than a quorum of the members participate in the initial communication, subsequent communication with other members will result in a quorum being present, essentially. So, you know, be careful in the conversations that you have, especially email conversations, because those can easily be forwarded to other members, so just be aware of that. And same thing with phone calls. I mean, if a discussion starts with two of you, you know, don't discuss that same phone call with more board members. So for example, a 5-member advisory board, 2 members exchange phone calls or emails expressing thoughts on an upcoming rule change, and they exchange the research that they have individually performed regarding the issue, and then one of the board members subsequently forwards the exchange to another member. Well, this is an example of a walking quorum. They've engaged in a small group discussion outside of a properly noticed meeting. So walking quorums can occur in many different contexts, conference call sort of context, video conferences, even hallway discussions, The big one to remember is electronic communications, because those are so easily forwarded along, especially when we're dealing with social media, so Twitter, Facebook. I would probably say err on the side of not posting anything about your board activities on those forums, because you're never really sure who's going to ultimately see it. On something like Facebook, friends of friends can see things. I would say really err on the side of staying away from those activities. A few other things to remember. Members should not meet in small groups, discuss board business, and then communicate those discussions to other members. Members should not send emails or text messages to a quorum regarding official business, even if each email is addressed and sent to each member individually. It's the overall effect that we're concerned about, not the specific steps of how the communication originated. Members should not create posts on social media about board business where a likelihood exists that a quorum of members could participate in those discussions. And members should not ask a quorum of members, even on an individual basis, for feedback or comments on board business outside the public meeting. This is called polling, which is essentially conducting an informal vote on an issue. Just a few guidelines as kind of shifting the conversation to the open meetings, the open sessions. A board is limited to discussing the specific items on the agenda. Again, we have to have those 7 days of notice, and so we don't want to stay outside of we don't want to stray outside of our agenda. During the public comment period, members of the public are given an opportunity to speak, and the presiding officer may set reasonable limits on commenters. You want to be careful during that public comment period, because oftentimes members from the public will bring up issues that are not on the agenda, and there may be a strong temptation to react to those comments or to engage in a discussion. But during public comment, your role is very limited to just receiving those comments, because they may stray outside of the agenda. So resist the urge to engage in discussion and just sort of receive the public comment. And if it brings up an issue that needs to be discussed, we can put it on the agenda for the next meeting. And that kind of covers this point as well. A few things members should do, sort of best practices: limit discussions to the specific agenda items contained in the notice. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Members should not respond to or discuss issues that are raised during public comment but which are not on the agenda. And specifically, members should specifically identify items for future agendas and communicate those items to TDLR staff. So if something comes up between meetings, if you could just contact our staff here, we can put something on the agenda for next time, if you'd like. Okay, so now we're shifting to what are some of the consequences of violating the Open Meetings Act. Well, first, there are potential civil remedies. Any interested person, including the media, may petition the courts to stop actions taken in violation of the Open Meetings Act. So essentially, they can get a court order saying, do not do this, you're violating the Open Meetings Act. The Open Meetings Act also specifically states that an action taken in violation of the act is voidable. So well after the fact, years down the road after a rule is adopted, if someone wants to contest that rule in court, they can go back to the adoption of that rule and say, look, this board violated the Open Meetings Act, so I shouldn't be subject to this rule because it's void from the very beginning, and that is a possibility. We also have the possibility of criminal penalties for a violation. Members who knowingly conspire to circumvent the act are subject to misdemeanor criminal penalties, and those penalties can be a fine of up to $500, confinement in county jail for 1 to 6 months, or both a fine and the jail time. So some more best practices. Avoid communications that involve a quorum of board members about official business outside of a properly noticed public meeting. During open meetings, confine discussion to items specifically posted on the agenda. So a few resources, if you want more information on this. The Attorney General actually has a handbook on their website, and it's actually a really good handbook. It kind of goes into the ins and outs of all of the Open Meeting Act requirements. It provides some Attorney General opinions on different circumstances that have come up. So if you have any interest in it, I highly recommend their handbook. They also have a training video on their website, and that would be worth checking out as well. If you want to see the actual text of the act, you can go to Chapter 551 of the Texas Government Code. And you can always call our General Counsel's office if you have any questions, and we can try to give you some guidance from our expertise. So any questions on the Open Meetings Act before we move on? Okay. So next we have the Administrative Procedure Act. And this is Chapter 2001 of the Texas Government Code. The purpose of the Administrative Procedure Act, sometimes we refer to it as the APA. The purpose is to establish minimum standards of uniform practice and procedures for state agencies and provide for public participation and transparency during the rulemaking process. Now, when we talk about a rule, it has a few different meanings, but generally it is a statement made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. So we kind of have a substantive element and a procedural element of the definition of a rule. And a rule is a statement of general applicability as opposed to specific applicability. So if the agency decides to take a certain course of action for a specific licensee, that would not be considered a rule because it's only applicable to that individual. Generally, when we talk about rules, we're talking about general applicability that will affect all of our licensees or a large, substantial portion of them. A rule includes the appeal of a prior rule, not just rules. Amending an old rule, or if we're an old rule, that can be considered part of the rulemaking process. A rule does not solely relate to internal management or organization of a state agency. Generally, it involves some interaction with the public or some standard that involves an interaction with the public. So if it's just an internal, like personnel management rule, not be necessary through the rule process internal. So there are a few different making or actions that's by needing to go through the process. The first one is legislative changes. If the legislature makes a new statute, oftentimes we will have to make new rules that implement that statute. Advisory board work may come up with an interesting idea, and so we may want to implement a rule based on those ideas, or even just generally an advisory board discussion. TDLR staff may come up with an issue, something that needs to be ironed out, and so we may come before you to introduce a rule that we've come up with internally. And we're required every 4 years to look at our rules to make sure that they're still necessary. We can readopt them if we decide they are necessary, or we can just decide that we don't need those rules anymore and we can just repeal them. But we do have to go through that process and analyze them every 4 years. And finally, any member, any interested person of the public can petition for a rule change on their own. So this goes along the lines of the interested person. Anyone may submit a petition to a state agency requesting the adoption of a rule. but they have to fit the definition of an interested person. So that is anyone who is a Texas resident. It could be a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. So basically, you have to be someone in Texas, whether it be an entity or a person. So, just quickly, this is sort of a map of how the whole rulemaking process plays out. First of all, we have an idea for a rule, whether that comes from the public or from TDLR staff or your advisory board. And someone has to actually take that idea and turn it into a rule, draft a version of the rule to be reviewed by everyone. And then we'll then present that rule to the advisory board for consideration. If the board decides to approve the rule for publication, we then publish it in the Texas Register, and that initiates the public comment period, which is a 30-day period. General counsel will review any comments received from that public comment period, and we may recommend rule changes in response to those comments. Once we've sort of figured out how we're going to respond to the comments and what our ultimate set of rules will be, we'll again bring those rules before the advisory board to allow you to review it, to make comments, and ultimately to propose the rules to the commission for final adoption by the TDLR commission. The commission will review the rules, any comments received, any recommendations, and if all goes well, they will adopt the rule for final adoption. That adoption has to be filed with the Texas Register, and then 20 days after that filing, the rule becomes effective as an agency rule. Any questions on this process? And then the rule review process is also laid out by the APA. As I said, programs are on a 4-year review schedule. The first thing we do is we publish notice of our intent to review the rule, to let the public know that we're going through this process now. So if they have any comments, they have 30 days to make those comments. Maybe they suggest to us that they don't think we need these rules anymore, and we can take that into account. General counsel will review the comments and make recommendations to the commission. And the commission will review the rules, the rule filing, the comments, and may readopt the rules. And the advisory board will be presented any comments and may recommend changes on their own. As far as the APA goes, again, the Texas Attorney General has a separate handbook specifically for the Administrative Procedure Act, which is also very good and very detailed. If you want to see the text of the Administrative Procedure Act, you can find that in Chapter 2001 of the Government Code. The Texas Register, which is where we publish all of the comments or any of the proposed rules, our notices for meetings are all in the Texas Register, and that's maintained by the Secretary of State. You can also find the text of the Administrative Code, which contains all the agency rules for all the various state agencies. And then, of course, you're also always able to call our General Counsel's office for any answers you may need. So any questions on the Administrative Procedure Act? Okay, moving right along. The Public Information Act, it used to be called the Open Records Act, is intended to allow each person information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official business. And this is an important point to remember. If you're using your own devices, your cell phone, even to send emails, if it's about advisory board business, that is a public record, even if it's on your personal phone. So this is an area where emails can kind of get us into trouble. In the worst case scenario, it's possible that someone could try to subpoena your phone to get that communication off of it. It's just something to keep in mind. So, be careful, what devices you're using and where you're storing these documents that are public documents. And again, the act is to be construed liberally in favor of granting requests for information. So if we're going to withhold something, we have to have a really good reason and a legal basis for doing so. So the process starts when we receive a request for information. So if you as a board member ever receive a public information request or what could be interpreted as one, be sure and forward that to our Office of General Counsel as soon as possible so we can figure out how to respond to it appropriately. And timeliness is very important because we have very strict deadlines to respond to these, approximately 10 days. And we can't ask someone why they need the records. We can ask them for clarification, do you want these records or those records? But we can't ask them to justify their request. There are some exceptions to disclosure. For example, certain information is required to be redacted, date of birth, email, certain educational records, and of course health information. So those will all be redacted from anything the department produces to a requester. So that's kind of the end of the public information aspect. There is another separate handbook on the Attorney General's website. They also have a training video to watch. You can find the text of the Act in Chapter 552 of the Government Code, and you can always call our office. So that concludes my presentation on this today. Are there any questions?
I'm not real clear on work groups, and therefore I want to reserve the right to call you back up when we discuss item H.
Absolutely. I'm happy to help. Any other questions I can answer right now?
Okay. More questions? Thank you very much.
Thank you.
Moving along to item E, public comment. Did we have anybody register for public comment? No. Okay. On to staff reports.
Good morning, Chairman, board members. I'm Lisa Hodak, Licensing Manager. And you should have the licensing statistics report in front of you that basically shows the fiscal year 2015 to fiscal year 2018 numbers, which includes the new licenses, renewals, total population for both auctioneer and associate auctioneer. The numbers are somewhat consistent. Last year we had 2366 for fiscal year 2018 for auctioneer population, and our associate auctioneer numbers were 73. So they're climbing a little bit. And do you have any questions on the actual report, the licensing report?
Looks like it stayed fairly consistent.
Yes. And I also passed out to you, just kind of wanted to show you the reciprocity states that we work with, and that's the colorful sheet that I passed out to you before the meeting. And I've included fiscal year 2017 and 2018 numbers. 2018, we had the most were Florida, which was 4, Georgia was 5, Ohio was 4, and we had 4 for Wisconsin. So this is just kind of something I just added just to kind of give you some information in case you were curious about the reciprocity states that we work with.
So how many are we with, is Texas with currently?
I'm sorry, say that
How
again?
many does Texas reciprocate with currently? We're not on the list.
No, well, these are all the states that we reciprocate with.
Okay.
Yes. So I didn't actually bring the full list because there may be some more. That was one thing I forgot to bring. But there's quite a few of them out there, and that information is available on our website.
Okay.
But these are the reciprocal licenses that we've issued over the last couple of years. Yes, sir.
I appreciate you doing this for curiosity's sake.
Good,
I've
thank you.
always wondered, but I didn't have a reason.
Well,
to ask.
there, you have it in front of you now. Thank you. And if you ever have, if you're curious about anything else, you know, for the next board meetings, I'll be happy to bring it to you. This just kind of came to mind, so I thought you might be interested, so.
I am interested, and I'm interested in how many out-of-state auctioneers we currently have licensed. Do we know that?
That I don't have with me, but I will bring that to you next time.
Okay.
You know, or I could also email that to you.
It's, next time is fine. I
Okay.
just- As we're looking at it and talking about it, that's one of the first thoughts that
Okay.
came to mind.
Okay, sounds good.
So Lisa, if I understand this correctly, Texas has formal reciprocity agreements with 21 other states.
Yes, correct.
And then each of those states has, like, for example, Wisconsin has, with its 4 neighbors, 4 of its 5 neighbors, perhaps. Is that what this is saying?
Well, no, what this is saying is that we've issued 4 Wisconsin reciprocity licenses.
Got it. 4 auctioneers from Wisconsin came to Texas and said, give me a license based on my Wisconsin license.
Correct. That
And
is correct.
We said yes.
Correct.
Okay. Thank
So
you.
that then answers my question, correct? I didn't state my question quite right. So we would have 4 Wisconsin auctioneers in Texas with a Texas license that are actually from Wisconsin?
Yes, correct. Now, they could we still might have a few out of state that didn't reciprocate. That could be a possibility. They may have taken the exam or something.
Okay.
So I can still look into that for you next time.
Okay. So that's the ones that wouldn't show up as somebody that came and took an exam?
Correct.
Okay.
And so Lisa, just to make certain that I understand this, are there other states that perhaps we have an agreement with that we simply haven't issued licenses in the last 2 years for?
Yes, it's possible. And I failed to bring that list with me, so I'll bring that next time for you. But over the last 2 years, we didn't issue to any other states.
Thank you.
Mhm.
Yeah, thank you very much for the list. It's
Sure.
very helpful.
Any other questions? Okay, thank you.
Item number 2, Customer Service Division.
Good morning, board members.
Good morning.
Misty Maldonado de Leon. I am one of the managers in customer service for this industry. As you could see on the report, we don't have very much traffic from our auctioneers and in our contact center. However, I do want to reiterate all the different ways they can contact us and which is the most efficient for them. Our contact center operating hours are 7 a.m. to 6 p.m. I would recommend 7 a.m. to 8 a.m. or 5 p.m. to 6 p.m. as the slowest hours that they could contact us by phone. We do answer a lot of their questions through email. The email address is cs.auctioneers@tdlr.texas.gov. On the landing page, we also have an email notifications button where they can actually sign up to get email notifications on laws and rule changes, upcoming meetings, any important notices they may need, so I recommend them do that. They can renew their license online, so that's also a great feature for them. If they do call our 800 number, which is 800-803-9202, we do have a new recording on there that offers them the help at email as well, so it's help@tdlr.texas.gov if they don't want to hold too long. But other than that, that's all I had for today. If y'all have any questions.
Questions? No questions?
I just have a couple. If
Okay.
that's all right?
Sure.
That's fine.
So are they able to leave a number and be called back, or they have to send it to the email?
We do have a callback feature,
You
so
do?
they are eligible to do that.
Wonderful.
I'm sorry, I missed reminding you guys of that. Yes, we do have that.
And then how many customer service representatives do you have in your contact center?
We are a team of about 51,
Wow.
so we do have some that work from home, and then we have some that work in the office. I'd say about 40. agents that actually are on the phones and answering emails daily.
Thank you.
You're very welcome.
Okay. Item number 3, Enforcement Division. Our favorite time of day.
Mr. Chairman, members of the advisory board, good morning.
Good morning.
My name is Michael Shirk. I'm a prosecutor. I actually work in the TOW VSF program, but I've been asked to cover your advisory board, and I'm happy to do so. It's a fascinating program. It's unlike anything else we run at the department. I had submitted some written materials talking about some illustrative cases, and I think it's an interesting report because it has the 3 different ways in which orders are issued by the department requiring reimbursement, refunds, or discipline against an auctioneer. As you know, the department is the manager of the Auctioneer Education and Recovery Fund, so that a claim is made, unlike most other programs, the claim is made directly against the fund. The department, of course, will then investigate an alleged violation of the Auctioneers Act and seek to determine if a claim is valid, and if so, how much amount of refund is due. Then, of course, we also take an equally important step, which is to discipline, sanction, or penalize the auctioneer themselves in the hope of achieving what are really the enforcement goals of prosecution, specific and general deterrence, to make sure this person doesn't do it again, and in the industry, we don't see that problem. I'll just run through the highlights. The first one was a big and fascinating and complex case that's still alive. This involves, as you see, just about a dozen claims because of the conduct of Vern Wallace as the auctioneer. Mr. Wallace had contracted with many people to auction goods and failed to pay the balances. After the auction, the department determined that the executive director was authorized to pay claimants from the Auctioneer Education and Recovery Fund. However, because the amount of the total claims against a respondent exceeded $30,000, and that's the maximum amount that can be issued against a single respondent, we had to put all the claims for reimbursement together, and we're going to determine the pro rata amount from the fund that can be paid to each one of the individuals. We're still trying to locate the respondent, the auctioneer, Mr. Wallace himself. His license has been revoked, but he's responsible for reimbursing the fund at 8%, as well as making up the difference between what the fund can pay on a pro rata basis to each one of the claimants and what they actually get. The second case is against Asher, and this was, again, a failure to pay monies after the auctioning of goods. This case had gone to a hearing, a contested case hearing at the State Office for Administrative Hearings. As you may know, the State Office for Administrative Hearings is an executive branch agency, unlike, say, the courts, which are judicial branch. The cases are heard there. The administrative law judge will then issue a proposal for decision, which can be either adopted or rejected or modified by the full commission. And that's how we have our adversarial proceedings in cases here at the department. The administrative law judge recommended, and the commission did issue an administrative penalty of $1,500 against this auctioneer. Because this was a first penalty, it was a relatively low penalty, and we did enter into a payment plan with the auctioneer. The next case is against Mr. Throckmorton, DBA Diamond T Auction. 2 orders were issued, one in September and one in August of this year, for a full administrative penalty, or each administrative penalty was $3,500 for a full administrative penalty of $7,000. This was an interesting case because it involved not the failure to make restitution to a person, but the failure to provide records during the course of an investigation. Our investigations are obviously very important, and when our licensees in any program, TOW, VSF, cosmetology, and auctioning, refuse to turn over records as are required, we will sanction them because that's our necessary source of information to make sure that we're pursuing the correct claims. So this penalty was issued for his failure to make documents available to the department upon demand. Then the last case I have is against Mr. Shuston, and that was an agreed order. We not only have cases before the State Office of Administrative Hearings, but oftentimes, every time we send out what's called a notice of recovery fund claim, letting the auctioneer know that a claim has been made against recovery fund, we always offer a settlement, trying to resolve things amicably with, if necessary, a penalty, but also restitution. This case was an agreed order in which an administrative penalty of $22.50 was assessed against the respondent for acting as an auctioneer without holding a license. In this case, the penalty has been paid in full. Then further down in my report, I just have some of the statistics for fiscal year 2018. As you can see by the number of cases opened and resolved compared for auctioneer compared to all of the cases opened and resolved for TDLR, it's not a significant portion, but as you can see by the staff gathered here together, it's an important program, and we've dedicated ourselves to making sure the programs run well. The collection of penalties is still pretty low. We assess penalties at $17,500 for fiscal year 2018. We've only collected $3,062 out of that. And I guess that's an area that some improvement can be made in. It's actually collecting the money that we assess. That is my report, a little bit of side information, but I'm happy to answer any questions you may have.
So for the recovery fund, we only had one payout from the recovery fund.
I can't say that. Let me just see, look at the stats real quick. I might be able to say that.
And we can wait till we get down to the recovery fund for that. But in the cases
That's
you
right.
highlighted, there was only the one for 30,000.
That's correct.
Okay.
Thank you for your time.
Just as a thought, or as a question, I assume and it's an assumption, that part of the low collection of the penalties is if they're no longer in business, you no longer can hold the auctioneer license over their head. What other remedies does TDLR have for collecting that money?
We have a couple of different processes we can use. One of them is, of course, is that a person can never get a license as long as they have arrears to us. And a person who's been in the business likely wants to continue earning their livelihood. The other remedy we have is to refer a case over to the Office of the Attorney General, and they'll reduce the penalty to a judgment. They'll go into court and get a judgment. And then they can use all of the techniques of any judgment creditor, including levying on property, seizing property, garnishment, and then also other licenses can't be obtained from us while there's a penalty outstanding. And I don't know if General Counsel has additional tools that we use.
Right, Della Lindquist, Deputy General Counsel. We also, it may not always get the money back, but we do have the authority for injunctive action, where we refer a case over to the Office of the Attorney General, not for collection, but to pursue an injunctive action to actually stop the person if they're continuing to act, if they're unlicensed and continuing to act in an unlicensed capacity. We do have the availability of bringing them to a hearing in civil court and then having an injunction assessed against them if there's continuing to harm people, and if they violate that order, then they're in contempt of court and they can be, arrested and put in jail. So that's sort of a path for some of these unlicensed people that just continue to go and go.
Okay. All righty.
Well, Mr. Sorford and members of the board, thank you for your service to the state.
Thank you, sir. Item number 4, Education in the Examination Division.
Good morning, Mr. Chairman
Morning.
and board members. My name is Brian Beal, and I'm here to talk about the report that we have for the examination statistics and trends, as well as the continuing education course provider and curriculum statistics. They seem to be pretty steady, actually since the last time we met in May 2017. Do you have any questions?
What was your last name?
Beal, B-E-A-L-L. Almost like the department store, but no S on it.
Okay. This your first time meeting for us?
It is, sir. It is.
Pleasure to meet you.
Nice to meet you, sir.
Mr. Chairman has a question.
Certainly.
Mr. Beal, how long I see you have these course approvals issued. I assume this is all continuing education, right?
Yes, sir.
Okay. And then how long is an approved course approved for? How long
1
often
year.
does it meet?
It's 1 year.
Every year it needs to be renewed?
Yes, sir. They can be renewed, or they just submit a different one, but yes, sir. The course itself is for 1 year. And that's why you can see where it kind of goes up and down on the total number of courses, because that's, maybe that particular month was the month that that course previously had expired or would expire on.
All right, thank you.
Yes, sir.
Any other questions? All right. Thank you
Y'all have a
very
great
much.
day.
Item number 5, financial services.
Good morning, members. My name is Jerry Daniels with the Financial Services Division, TDR. I'm here to report on the Auctioneer Education Recovery Trust Fund. The most important reason I have to report is that in Chapter 1802 of the Occupations Code, it says, if the balance in the fund on December 31 of a year is less than $350,000, each license holder at the next license renewal shall pay, in addition to the renewal fee, a fee that is equal to the greater of $50 or a pro rata share of the amount necessary to obtain a balance in the fund of $350,000. I believe you have in your materials a report as of August 31st for the first 8 months of the calendar year. At that time, we had over $350,000 in the fund. As of today, we have over $361,000. And unless there are current enforcement actions that would affect the fund, we'll probably end the year with approximately $380,000 in the fund. So the $50 renewal fee will not be required. I do want to speak to one other weapon that the agency has if a person does not pay their fines or penalties. We also have the warrant hold mechanism, so that if the state were going to pay that person anything for any reason, and they have a hold, then we apply the hold. They won't get the money. They'll make out the warrant, but it'll be paid out to us instead. That's just one more tool that we have.
One more tool. I like that tool.
And most of that 30,000 that was it Wallace? Yeah, that was paid last year, in the
Okay.
last calendar year. So I think we're in good shape for this year.
Looks good. Good.
Are there any questions?
Questions for Jerry?
Jerry, just one question. So you said if the fund balance falls below 350,
At December 31st.
then for the next renewal cycle, and the renewal cycle is simply 1 year?
It is at this time, yes.
Okay, so everybody, since on 12/31 of 17 it was below, so everybody this year is paying $50
Yes.
extra?
Now, we don't always make that go into effect until maybe, like January 20th, or, it depends on when the renewal notices are sent out.
Sure.
But I believe this year it did go into effect January 1st. So, yeah, for one renewal cycle, after the date, we put it into effect.
Thank you, sir.
Any other questions? Thank you very much, Jerry.
Thank you.
Item number 6, Regulatory Program Management Division.
Good morning, members. My name is Russell Tolley. I'm the program specialist for the Auctioneer program at RPM. Since the last time this board met, there's been a change in our division, formerly known as the Compliance Division, now Regulatory Program Management. We have some new leadership, new in their positions, but not new to the agency. David Gonzalez he's back here. He's now the director of the division. Lee Parham is his assistant director. And there's a section head who's new to the division as well, Charlotte Melder. Charlotte here? There she is. Charlotte's a longtime TDLR enforcement attorney who's now moved over to RPM division. The division is ready to do any research you might have, answer questions you have, the public may have, auctioneers may have. We're also available for attending any conferences or work group meetings you might be having. We're available to talk and represent the agency. That's generally my role here. And that's about all I have to say for today's meeting. If you have any questions, I'll be happy to take them.
Any questions?
Thank you.
Thank you very much.
I just had one thing to add, I'm sorry. Della Lindquist, Deputy General Counsel, with regard to Vern Wallace and that whole conglomerate of cases, we have not paid anything out yet on those cases. We still have a couple of more claimants to review their claims and see if they're viable. We are very certain that the aggregate of those claims will exceed the $30,000 cap. So we're waiting to see everybody's claim to come in. And then most people, if they get paid, something would be a certain amount of pennies on the dollar. It won't be, some of them have low claims and some of them have higher claims based on what he did. But we have not paid, maybe have paid something in the past for him, I'm not sure. But for this group of claims, we have not actually made that payout yet. We still have a couple of more claims to assess in the enforcement division. So I just wanted to make sure.
So that 30,000 is still sitting in the recovery fund, or has it been moved out?
Right, we haven't paid anything out, so I'm assuming
Okay.
it's still there.
Okay.
For this particular group. Maybe in the past there were some claims paid, but we are waiting to get all the claims in, determine the bottom line. Our commission has asked us to do that. We assume it'll be fairly soon when we make a final determination and see
Okay.
what we can pay out to people.
So we could be looking at going below the 350 mark.
Well, we can't pay more than 30,000. That's the
Well, he's
cap.
got a projected budget of 380 projected at the end of the year, so.
Right, it could be.
Be rather close.
We get very close.
Okay. Maybe we need to have some guys go ahead and pay early for next year. Thank you, Dell. And on to item number 7, the executive branch.
Thank you, Chairman. Carla James, TDLR. Got quite a few things to talk to you about. It's been a long time since we visited with you. I wanted to reiterate what Russell said. We do have some new leaders in our regulatory program management, but those folks have been here quite a long time. And to let you know that the reason for the change is we lost our director, George Ferry, last year. And so wanted to make sure you knew the reason for the change. Very highly competent and exceptional staff to take his place, so we're very comfortable with that. We have gone through a couple of things since we met with y'all last. The strategic planning process is something that every state agency is required to go through once every 2 years, and we did that this last spring in April. We traveled around to 5 cities in the state and had discussions and town hall meetings with our licensees and the general public to find out what we're doing well and what we can improve on. And we took that information coupled with an online survey that we provided to Texans to take and took the 8,000 comments that we had, and yes, I said that correct, 8,000 comments, and broke them into different categories such as legislative changes, rule changes, internal process changes, and that's how we created our strategic plan, which was submitted to the legislative body and the legislative agencies back in June, I believe it was, but don't hold me on that date. So that essentially tells the legislature what our licensees and the general public found of interest that they wanted to comment or change. And so that will be a starting point for us, and the legislature will determine what changes they see necessary for this next session, which begins in January. So that's the first of the process that we start with for the legislative session. The second part of that process is the legislative appropriations request, which is also required by state agencies once every 2 years. And in that, we set forth what our needs are for the next 2 years based upon what we saw in the strategic planning process. And so, as all state agencies do, we have requested some additional items, which we call exceptional items, and we set forth 4 this time. The first and our priority is the creation of a licensing system. Currently, TDLR runs off of 9 disparate licensing systems, which means all of our customer service staff and licensing staff have to work off 9 different systems just to get licenses out the door and to assist folks. And so it has come time, and probably well past time, for us to request the funding to do that. We've requested the budget authority. As you're aware, this agency funds itself through our fee structure. So we're hoping that that will be well received, and then we can move forward in building a system that will take all of our licensee base and put it into one. After that, we have requested funding for a human trafficking team. We have a unique position in this state in that through our inspection process and our licensing process, we have access to a lot of businesses that could be involved in human trafficking. The Governor's Office and the Office of Attorney General have taken this to be a very high priority, and so we are following in line with that and requesting some additional staff to address that and help us gather information and be a conduit of information for the parties involved, and work closely with local law enforcement to provide training on how to identify human trafficking, and just to provide data to them, because we are not a entity that will go in and arrest folks. We provide that data as we see it. Our third and fourth exceptional items kind of go hand in hand. All state agencies were required to make a 4% cut during the 85th legislative session, and that equated to 4 staffing positions for us. We have requested 7 back in our areas of licensing, customer service, inspections, and enforcement, to try to get us back up to at least the levels that we're comfortable with. Obviously, we would like to have the 14 staff members back, but we have been frugal and conservative in our request and requested those 7. So that kind of encapsulates all of our legislative appropriations request information. Since Nick is not here, he's our chief of staff and is the person in charge of our Office of Strategic Communication. I promised him I would give you some information on the Auctioneer's website. So over the last 6 months, there have been 17,104 page views, which is an average of 93 a day. 46% of those visitors have accessed your site on a desktop computer. 49% did so from a smartphone, and 5% from a tablet. And the top reasons for visiting the Auctioneer site is online licensing, FAQs, the Auctioneer's laws, schools, and then administrative rules. So we see a lot of traffic for the small number of licensees that we have, and that's encouraging to us. We know that they're taking advantage of the information we have out on our website.
And the website's very easy to navigate.
Thank you. We appreciate that. That concludes my remarks. I'm happy to answer any questions you may have.
Douglas, I know you have one.
No, I'm good.
So strategic planning is every 2 years?
Yes, sir.
Okay. All right. No questions?
Thank you.
We will move on to South Dakota versus Wayfair,
No,
or before that?
I'm before that, I think.
Okay.
The rules, G. Good morning, board members. My name is Della Lindquist, Deputy General Counsel. And just as a reminder of what Derek spoke about earlier, we are in the 4-year rule review for the Auctioneer rules. We published, the whole point of this first phase of the rule review is to verify that the rules are still necessary, and based on the fact that we still have the statute to enforce and regulate the Auctioneer program in Texas and implement all of that, we determined that they are still necessary and are still needing to be readopted and gone on with in the second phase. We published them on August 24th. The public comment period closed September 24th. We did not receive any official public comment. However, I do know that at least one of you has ideas for some rulemaking that you might like to do in the upcoming season. And I know that some staff here also have some ideas for perhaps strengthening the consumer protection part, maybe some of the section in 6770 that relates to the requirements and standards for auctioneers. So as we head into phase 2 of the rulemaking, which is, we've readopted the rules, we will ask to do that. We would, as you can see later on the agenda, maybe appoint a work group or two. And we can discuss that. You had asked Derek to come back to do that. But what I needed for you to do today is to agree to readopt the rules, to recommend to the commission at their meeting on November 30th to readopt these rules without any change at this time. And then we will go forward with phase 2 of the rulemaking process to look and take a more in-depth look at the rules and see if any changes are necessary.
I so move.
Norman Seaton makes the motion. All right, second. Second. Rick gives a second. All in favor?
Aye.
Aye. All opposed? Motion carries.
Okay, and they would be then effective December 14th.
Okay.
Unlike a traditional rulemaking, when we do rule review, the rules don't, it's not a 20 days after they're published again, it's immediately on the day they're filed or published.
Okay.
So that's why we don't have to wait 20 days after the November 30th meeting. Any questions? Okay.
Thank you, Donna. Item H.
Let's go to We're back. Item H, you had mentioned to Derek before that you'd like him to come back up. And basically, as I mentioned before, if you have any questions about how the work groups work, we're happy to answer any questions. But we thought you might, as we take a more in-depth look into the rules for Phase 2, if there's particular changes you want to make or topics you've identified, it's a lot easier when you have work groups. And all we require that there's no quorum of the groups, because then we'd have to post it as an open meeting. So smaller groups of you, 2, maybe 3 at the most. And you can do it any way you like. You can focus on different parts of the rules, like the enforcement part or anything else, and do separate work group for that, or you can just appoint a work group that looks at the whole set of rules. We will defer to you for that.
Okay.
When you set up a work group, is that this group only? Can other people come in? And what's the restrictions to work groups? I've never participated in one.
Oh, okay. Well, the work groups, traditionally, no quorum of you. Sometimes there's an appropriate time when an outside group might, someone from the that's not a board member or staff is present. When you first start looking at the rules, it's probably not as appropriate. But sometimes to get expertise, we've done that in some of our other programs like Waterwell. We're kind of discussing some topics in Waterwell that do require extreme expertise from people in different industries. So you can certainly consider if you need somebody to participate in it and you feel like they can lend some expertise that is not within our group, you could invite somebody.
Do we have anything, we haven't had any public comment on proposed rule changes or anything. What are we going to assign to the work group?
Well,
do we have anything for
what
them?
you might want to do is, if you assign the work group, there are some ideas from staff
Okay.
that we can let you know. And the staff ideas came from strat planning, and they are ideas to strengthen the consumer protection and maybe standards of practice in 6770 of the rules, to maybe add some more, I guess, teeth, if you will, for consumer protection. I know that Mr. Seaton has mentioned the CE, some issues regarding CE. We can invite some of our E&E folks to the work group meeting. I don't have any other specifics. It may be a time for you all, just an appoint a work group to just go through the rules and see if there's something that's obsolete or something that you just feel should be there. I don't know if there's going to be any bills filed that affect this law during this session. I don't know of anything, but that could impact what we do in the
Mary
spring.
Winston, TDLR, sorry, Della. During the May 2017 meeting, there was a discussion about a possible educational work group. I know Mr. Seaton does have some concerns specifically or interest. Typically, the work groups do consist of a non-quorum set of members of the board or council, and it's facilitated by staff. So if we'd have the educational work group, it would be our examination and education team. Someone from there would contact the members of the work group. Work groups are chosen by a presiding officer, and that doesn't have to be a motion. That's just your choice. And during that time period, you would figure out, like Della's saying, what your topic is that you want to discuss. Mr. Seaton, you have some general things that you want to discuss. That would be the time that we could hone in on something specific. Contact would be made by members of our staff. And if it was an enforcement work group, that would be an enforcement staff, rules, that sort of thing, RPM staff. And of course, we would also talk to Derek or Della from our general counsel office. Times that would be established by that group, facilitated by our staff, and they can be conducted via phone, smartboard. There are different ways. So you wouldn't have to come back in physically. And we do have a lot of different work groups that do meet remotely.
Okay.
Derek Burkhalter. Just one thing to remember, if you do participate in a work group, it'll be very tempting to report your progress to other board members. But just remember our open meetings rules. Be sure and do not communicate anything with enough board members to create a quorum. So there will be a certain degree of having to keep a secret from other board members for a while, which may feel unnatural, but do remember if you participate in those work group meetings, it is a requirement.
Okay. So, Norman, are you willing to take on the
Yeah.
education work group?
I'll make a statement here right quick.
Okay.
Last time I wrote up real promptly before I got to the meeting, some, what do you call them, agenda items. And immediately this whole group back here, I said, work groups, can't do that. And so we had to shut up. So I went back and I said, okay, what did I do to cause that problem? And everything I got in there, I still want to do. I just phrased it incorrectly. And now I come up with a much easier way to phrase it. So that's, yes, we need an education work group because of all the changing laws.
Okay, so we'll appoint Norman Seaton as an educational work group.
By work group of one?
Better
Well,
not, probably two.
It would be better with two, but I'm thinking we may need two work groups. We'll have another one that can work with the staff, just on 6770.
It's fun to nominate people who aren't here, too.
I just worry about them following through, it'd be the only thing.
We've been through that, haven't we? Why would you on that?
Okay, I'll help Norman with his. And then we'll also create
Doesn't speak specific statements.
another work group. Rick? We'll take that on to work with the staff to strengthen 6770 or to look at 6770.
So more of an,
And
Della Lindquist, so more of an enforcement, consumer
yes, more of an
protection.
enforcement.
Okay. Work group with Mr. Stroud?
Yes.
Okay.
You want me to take that on too?
Well, if you'll help out with Rick, I'd appreciate that. Thank you. That puts two of us on each one, and the four of us that we know will follow up and participate.
Okay, and it would probably be a good idea if you all read through the rules. That's just very helpful just to see if you've identified areas in your particular work group area
Okay.
that maybe we don't know about or we haven't thought about, but as your profession has advanced, we need to, that's what you're here for, to advise us, so.
And we'll coordinate with Christine also to make sure that
Yes.
we're all looking through the right parts of that.
Right.
for the
And Mary
respective
Winston,
work
one more
group.
time, don't have to worry about figuring this part out. The staff will contact you.
Okay.
So
Okay.
I see Brian Bill nodding. Enforcement staff will reach out, and then they'll coordinate to make sure your availability.
Okay.
Okay.
Thank you, Mary.
Thank you.
Thank you, Della. Thank you, Brett. And Norman, be careful what you wish for, it may come true.
Been there, done that.
All right. Item number I.
Okay, you have another session with me. So I would like to present a Supreme Court case that came out over this summer, which could have large implications for auctioneers, especially anyone who does online auctions with sales to out-of-state buyers. So the case is South Dakota versus Wayfair Incorporated. And the issue that this case deals with is, in its most basic terms, can a seller be held responsible for the payment of sales taxes to a buyer's state if the seller has no physical presence in that state? And when we say physical presence, we mean that they don't have any storefronts, they don't have any facilities, they have no distribution points. Basically, they have no real estate in that state, and they have no employees, they have no personnel, no sales representatives or anything like that. So, you know, an example, of course, a modern day example would be internet sales, but I guess older examples would be like a mail order catalog firm or something like that. So in analyzing this type of interstate commerce, commerce between the states, we first have to start with the Commerce Clause of the Constitution. Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Of course, the key phrase for us is among the several states. And so the Constitution gives the United States Congress the ability and the power to regulate interstate commerce. The Supreme Court has interpreted that to say, yeah, the states can regulate commerce, interstate commerce to some degree, but they have, throughout its cases, have established two primary principles about that state regulation. States may not discriminate against interstate commerce. They can't throw any barriers in the way that makes it easier to do business with in-state businesses as opposed to out-of-state businesses. So they can't, you know, create a barrier. And states may not impose undue burdens on interstate commerce. So a state might try to say, okay, we're treating everyone the same. We have the same regulation for in-state and out-state, but it could be that that equal burden is excessive or undue when applied to the out-of-state businesses. So with those two primary principles, the court established through its case law what has been called the physical presence rule. And this is the old rule before this case came along. The physical presence rule says a state may not require a business to collect a sales tax if the business lacks a physical presence in the state. Instead, a state must rely on its residents to pay a use tax on purchases from out-of-state sellers of goods or services used or stored in the state. So the use tax is at the same rate as the sales tax, and basically it just says, okay, we can't require these out-of-state businesses to pay the tax, so on those sales, we're going to impose the tax burden on our in-state citizens, on the buyers. So, you know, that's the theory behind a sales and a use tax. The problem is getting the consumer to actually pay that use tax on their own. I mean, who is going to keep track of their individual purchases and say, well, I didn't pay a sales tax for that transaction, so I'm going to make sure and set money aside for the use tax and pay that at the end. In practical effect, that just doesn't happen. It's very difficult to enforce that on the citizens of the state, and it's if they tried to do that, there would probably be a big outcry about it. And so this physical presence rule, these are the two Supreme Court cases that have created and solidified that rule, a 1967 case and a 1992 case. And both of those cases dealt with mail order catalog purchases. So even when those cases were decided, there were some pretty heavy dissents. There were a lot of reasons that, some of the judges didn't like those rules. The first problem is it creates a sales tax loophole for out-of-state businesses. Even though consumers are supposed to pay the use tax, the fact is they really don't. And so it results in a de facto sales tax loophole. And in fact, some of these firms advertise the sale of their products as being tax-free or sales tax-free, which is, kind of deceptive because they don't mention anything about the use tax. But this does create an unfair advantage for out-of-state businesses who don't have to collect the sales tax and then pay that back to the state. So they can offer their consumers lower prices. This also creates an incentive for businesses to avoid physical presences in multiple states. If you can get by without having a physical storefront or any employees in a state, you're going to do that because you want to take advantage of that sales tax loophole. And so this has the effect of making fewer storefronts, fewer employment centers, fewer distribution centers in multiple states, which, has effects on employment, has effects on revenues in those states. The physical presence rule also fails to account for the virtual presence of online activity. When you're focusing on physical storefronts, you're failing to acknowledge the fact that someone can go online and have a virtual showroom of all the products that is actually more accessible than a storefront down the street would be. And so this rule kind of creates market distortions by failing to accept that reality. And finally, of course, because buyers just don't pay that use tax, that is a big loss of revenue to the states who might otherwise be able to collect that sales tax through the business. And states that do not have income taxes, they rely heavily on sales taxes for their state revenues. And so that, is a really big problem for a lot of the states. And it was a big problem for South Dakota. And so in 2016, South Dakota said, we're going to go ahead and just enact a law requiring out-of-state sellers to collect and pay to the state, remit, sales tax as if the seller had a physical presence in the state. They did carve out some exceptions, so it doesn't just apply to anyone selling out of state. It only applies to sellers that deliver more than $100,000 of goods or services into the state annually, or sellers that engage in 200 or more separate transactions for the delivery of goods or services into the state. So they did carve out, a little bit of a definition beyond just selling into the state. There's a little bit of a practical problem with having a dollar amount like that, because you as a seller might not anticipate having that much of sales into that state in a year. And so if you're going along with that assumption, you're not collecting that sales tax. But then you may have an unexpected surplus of sales, and then all of a sudden you've crossed that threshold, and now you will have to pay those taxes for all of your sales. And so, you may have to go back and somehow retroactively collect those taxes, because now you've bumped up into this category where you now have to pay the sales tax. And then a practical problem with the 200 or more separate transactions, that could be little tiny minor transactions. You might sell 200 pencils separately, and now all of a sudden you have to pay sales taxes to that state.
In other words, that could be items in an auction.
Correct. Yeah, you could sell maybe 200 items in one auction. Right. That's a good
It's
example.
all of us.
So South Dakota went ahead and passed that law and said, we know that this violates the Supreme Court cases, but we want the Supreme Court to reevaluate this area of the law because of all the injustices I pointed out. And basically that was their strategy. We're going to push forward and ask the courts to overturn this old physical presence rule. So the retailers that South Dakota was targeting, first of all, is Wayfair, which you may be familiar with. They're an online retailer of home goods and furniture. I think the information said that in 2017, Wayfair had something like $4.7 billion of annual revenue. Overstock.com is another online retailer. They sell a wide variety of things from home goods and furniture to clothing and jewelry. I think they had an annual revenue of $1.7 billion in 2017. And finally, Newegg Inc., which I had not heard of, is an online retailer of consumer electronics. So these are the three defendants in the lawsuit, essentially. These companies all have no employees or real estate in South Dakota, but they all met the minimum sales requirement, the $100,000 threshold, and they all met the transaction requirement, the 200 separate transactions. And so South Dakota files suit on them. They were seeking a court order to say that its new sales tax law is valid and that they can apply it to the retailers and force them to collect sales taxes. During the suit, South Dakota essentially conceded that, yes, its law is inconsistent with the prior Supreme Court decisions, but they basically said, you know, it's time to change this law. We need the Supreme Court to change or overturn its mistake that it made with the physical presence rule. So the lower courts decided with the retailers and said, you know, no, we know what the old law is. The Supreme Court has told us. So the lower court dismissed the case outright. The appellate court looked at the case and said, no, we agree with the lower court. You know, it should be kicked out. And the Supreme Court, they appealed to the Supreme Court, and the Supreme Court said, no, we will accept this case. We want to take a look at this and decide if we need to change our decision in this area of the law. And so just this past June, on June 21st, we got the court's ruling. And they came out and said, no, we made a mistake in those past decisions, and the physical presence rule is now overruled. It is no longer the law of the land. And they gave us it's actually kind of an older standard, but this is what's left when you take out the physical presence rule. The court will now uphold a state's tax if the tax applies to an activity with a substantial nexus with the taxing state. And this was typically covered by the physical presence rule. They said if you have stores or if you have employees in the state, then that's a strong enough nexus or link with the state to justify taxing them. So we still have that prong of the test, but the physical presence rule is no longer a factor of that prong. Secondly, the tax has to be fairly apportioned. It can't discriminate against interstate commerce. And it has to be fairly related to the services the state provides, which is a little bit confusing, but in this context, basically, the businesses are receiving the benefit of access to the market of the consumers in that state and the stability of the roads, the police protection, and things like that. So those are the services the state is providing that these companies are taking advantage of by selling their products to those consumers. So the fourth element here is it has to be related, you know, those two concepts have to be related. And so the court took a look at South Dakota's specific law and said, you know, with this new standard we're using, the substantial nexus requirement, that first element there, is required or is satisfied with South Dakota's law as applied to these retailers based on the economic and virtual context that those retailers have in South Dakota, because they have websites that all of South Dakota's citizens can access easily. Sometimes you're downloading an app from that business onto your phone, so that, you know, the court takes into account this virtual presence that these businesses have in the state. So what does this mean for Texas auctioneers? Basically, a Texas auctioneer that has no physical presence in a buyer's state can be held responsible for payment of sales taxes to that state if, and this is a big if, the auctioneer's activity constitutes a substantial nexus within the state. The standard is no longer physical presence, so the relevant factors we're looking at now are the value of the goods or services delivered into the state. And so they looked at South Dakota, actually placed a limit here, the $100,000 per year limit. So the court kind of liked that and said, yes, that's a relevant factor, and South Dakota has included that factor in their law.
Sir, 1 second.
Sure.
Nexus, what's that mean?
Nexus is like a link or a connection.
Like a website?
Right, exactly. So, if the business maintains a website that is accessible within that state, that's a link between that business and that state. It's some way that they are targeting that state. It's not just some random association. There's actually a link here. They're, making themselves available to the citizens. So nexus is kind of a legal term, but it essentially means connection or a link. The second factor the court looked at is the number of separate transactions within the state, and again, South Dakota had that covered. So far the court likes South Dakota's new law. And then the court also mentions in its opinion the virtual presence within the state through online activities. The court doesn't tell us how much emphasis they placed on this third factor, but they did mention that as a relevant consideration. So, whether or not an auctioneer's activity constitutes a substantial nexus with another state will be looked at by the court through these factors. Again, we don't know, would virtual presence alone be enough? We don't know that. The court doesn't tell us that in this case because that was not the situation before them. They can only decide the case that's before them. So it's possible that just having a website that's accessible by citizens in another state could be a strong enough link or nexus to make you liable for sales taxes. We just don't know the boundaries of this new rule yet. So one of the difficulties with this new possibility that you may have to pay out-of-state taxes is that there's such a complex web of sales tax jurisdictions. We're not just talking about states here. Some cities have their own sales taxes. Counties could have their own sales taxes. So when you look at the United States as a whole, there are literally over 10,000 jurisdictions that levy sales taxes.
Thank you for answering my next question.
Oh, sure. And each of these jurisdictions, they have different tax rates, of course. They have different rules governing tax-exempt goods and services. An example that they cite, Texas taxes regular deodorant at its regular rate, but if the deodorant has an antiperspirant, am I saying that right? Mm-hmm. Then it's not taxed. So that's just, a small variation, and each state, each jurisdiction is going to have its own little separate rule like that.
I do have a question.
Sure.
Can I Google and find the tax rates for an individual city?
I would expect that you would be able to, but, it could get difficult. Some states, some cities are going to have a more accessible online presence than others. It may not be required that they have an online posting about it.
Unless it's there, it's going to be very difficult. That's for
Exactly.
sure. Keep in mind, I'm a database programmer.
Okay.
That's what I do for a living.
Okay.
So,
Well,
As an auctioneer, typically, when you went out of state like that, you went to the local tax assessor collector for clarification of what taxes were applicable to you.
so now we're going to the whole United States.
Well, and we'll talk about some possible solutions in just a moment here. All of these states could have different product category definitions, and also different standards for determining whether sellers have a substantial presence in their jurisdiction. I mean, we saw what South Dakota's rule was, but now each state are going to have their own version of that rule, and they're not all going to be the same. They're going to vary pretty widely. So, what can we do? What can the small businesses do that, you know, can't afford to hire their own legal department to research every tax jurisdiction? Well, we can hope that Congress acts. Congress can, because they have the ability to regulate interstate commerce. They could pass a set of laws saying that this is how the interstate sales tax system will run, and they can standardize it. They can, you know, they have great flexibility in what they can do. But, you know, with the reality of the political situation as it is, you know, people probably shouldn't hold their breath too long, hoping for Congress to resolve it soon. But it is possible, and maybe it is something that there can be bipartisan support behind. Another possibility, and this is something that some states are doing, is basically agreeing with each other among the states to treat their sales taxes uniformly. And right now, 20 states have agreed to the Streamlined Sales and Use Tax Agreement, and my next slide will go into this a little bit more. The court, in their opinion, was really optimistic that the market would fill the need for this new information about tax jurisdictions with a tax compliance software. And the court was very hopeful that this could easily be developed and be made very cheap. The problem with any sort of tax compliance software is because our tax laws are constantly changing among the 10,000 jurisdictions, you would essentially have to buy a subscription to that service so it can be constantly updated. And there's no telling how expensive that would be. I mean, you know, it seems like quite a daunting task to keep up with all those tax jurisdictions. And so the price for a service like that could be beyond the means of some of the smaller businesses. And then the final sort of option, the least desirable option, is to hire or contract with tax professionals to figure these issues out for you. So this is kind of the range of, you know, possible solutions for the problem that we now have. As I said, some of the states have taken their own initiative to agree with each other. 20 of them, not Texas, have signed on to the Streamlined Sales and Use Tax Agreement. And the idea is to standardize their taxes and to reduce compliance costs. So this agreement requires each state to have a single state-level tax administration. So rather than having, you know, different counties and cities, the states who have signed up to this say, no, for our state, there's one tax rate when we're dealing with other states. It also provides uniform definitions of products and services, so we can all agree, you know, if we want antiperspirant in our tax deodorant or not, things like that. Simplified tax rate structures, again, try to make uniformity, try to make simplicity among the states. And this last point is a big one. It provides sellers access to sales tax software paid for by the states, and it also provides businesses immunity from audit liability if they're relying on this tax software to pay their sales taxes. So, you know, this may be kind of a starting point for federal legislation. I wasn't able to get too deep into the research as to how this is, you know, if the states are happy with this agreement or not, but this is kind of a creative solution that may be a starting place for all the states kind of getting some uniformity for this issue. And so, you know, how has Texas dealt with this issue? Well, this decision came out over the summer. We haven't had a chance yet to have the legislature meet to discuss the issue. The Comptroller's Office did issue a statement, and they've said that they are reviewing, and they've actually at this point published proposed amendments to their rules in the Texas Register, their tax rules. And the rules that they've published have basically established the sales threshold at $500,000. Remember, South Dakota had theirs at $100,000, but Texas's comptroller has set it at $500,000. If the rulemaking process goes as planned, they're hoping for this to take effect January 1st of 2019, but they are going to postpone the enforcement of their rule until October to give everyone time to learn about the new rule and adapt their business procedures to it. They just posted these new rules for public viewing. It's coming out in in fact, it already is posted online. People can go and make public comments on the Texas Comptroller's, whatever avenue they have for receiving comments. The period is open until November 18th to do so. So if you're interested, definitely go look at those rules and definitely make comments. And finally, it's possible the Texas legislature may address this issue in its upcoming session, but we just don't know. So that's all the information I was able to find on this topic, but I'll do my best to answer any questions if y'all have any.
Certainly opens up multiple taxing authorities also of who is due the tax. The state that it came from or the state that it's going to?
Right, yeah. And it's also important to remember that this ruling is only about sales taxes, so it might be tempting to expand this thinking into, we can now make out-of-state sellers get licensed, or, we can do other things, but this is a very limited ruling that's only talking about sales taxes.
Questions, comments?
Is this something the work group should look at? Or is it just something we
Well-
should wait on just to see what happens?
I think we want to first wait to see if the legislature does anything.
Okay.
If they did, then definitely we would want to have a work group. We would have to create and implement our own rules to implement whatever the legislature does. So we'll just have to wait and see.
I vote for waiting.
Yeah. There's a lot of uncertainty in this whole area right now. So, we'll see what happens, but I can almost guarantee you that every state is going to have their own version of this new law because they all want to take advantage of that extra revenue.
Thank you very much. You made it simple. I read through 90% of that. But
Oh,
you made it a lot easier.
well-
I might have held off reading through it if I'd have known you were going to make it so easy.
Well,
Did you understand it?
Yeah, bonus points for reading the whole decision. I included it, but I didn't necessarily expect everyone to get through it, but good job for trying.
Any other comments, questions? Thank you
Okay.
very much, Brad.
Thank you.
Item J, recommendations for agenda items, next board meeting. How about report from the work groups?
We have that. Carla James, TDLR. I think you also wanted a licensing information update related to out-of-state licensees and reciprocity numbers, if I understood that correctly.
And we did answer that question later on, so I don't know that we need a whole lot
Okay.
more there.
Very good.
I do have a question of everybody on this panel over here. You are very well aware that I shipped a memo and asked what to do with it. Since it goes directly under the education work group, do I need to be mentioned?
I don't believe so at this time, sir. Carla James, TDLR. I think that's the reason we want to put the education and examination work group together so we can dig into that a little bit deeper.
Okay, thank you. That's
Actually-
what I thought you'd say.
Yes, Mary Winston, TDLR. We do have this, Mr. Seaton, but E&E does not have this. They do now. They do now. So I'm assuming this will kind of serve as maybe the basis of that first conversation that you have with Brian Beal. So, yeah, we do have it. Brian, have you seen it yet? Okay, so, thank you. That's a great foundation.
Okay.
Item K, unless anybody has a date in mind, we'll defer to the director and the commission for our next meeting.
Carla James, TDLR. I think we're looking sometime late spring of next year. So I think Christine will just be reaching out to you. See how the calendars look. It's a little bit early for y'all to have your spring calendars done. Or I assume if you do, then you're way better than I am. So.
Well, it'd be nice to have a little bit of the legislative calendar so we know what's happening with the
Sure.
sales tax issue also.
Sure. And the session is supposed to go through near the end of May. So we may even if that's part of what you want to talk about, it may be appropriate to have it later in the spring rather
That
than
and anything
earlier.
else that comes up during the session.
Great, thank you.
All right. Anything else? If not, consider us adjourned.